Welcome back to the deep dive. Today we're tackling a really essential area of law, especially if you're involved in the commercial world. That's registered trademark rights.
Hmm.
Specifically, we're plunging into what happens when those rights are infringed and maybe just as importantly, how someone on the receiving end, the defendant, can fight back.
That's right. Yeah, having a registered trademark gives you these exclusive rights, but, they aren't totally absolute. Understanding infringement is really about knowing where the line is.
Right.
And understanding the defenses is about knowing when someone else might actually be operating legitimately, even if it seems quite close to that line.
Okay. And it's important to mention this deep dive is built on essential study material. It's brought to you by Sinorbit Academy, Sri Lanka, and it's created using educational materials made available by the University of London.
Mm-hmm.
So this is designed purely for educational purposes, really to help you get your head around these concepts, especially if you're getting ready for exams.
Yeah, absolutely.
And for all of you studying this, seriously, good luck for all of you for the exam.
Yes, best of luck. Our mission today is, well, pretty clear. We want to take those statutory rights a trademark owner gets and really explore what kind of conduct actually crosses the line into infringement.
Okay.
Then we'll flip it. Look at it from the defendant's viewpoint, breaking down the arguments, the specific statutory defenses they can raise, and all the way through, we'll be highlighting those critical nuances, the interpretations that come from landmark cases.
Yeah, the case law is key, isn't it?
Absolutely. Particularly from the UK courts and, crucially, the Court of Justice of the European Union, the CJEU, their judgments have just profoundly shaped this whole area of law.
Definitely. So we're going to structure this a bit like tackling a problem, step by step. First, the basics, what infringement actually is.
Hmm.
Then the specific actions that count as infringing acts. And crucially, we'll spend some real time defining the scope of the protection. When does using a sign actually infringe?
Right.
From there, we'll pivot completely, look at the defendant's side, those statutory defenses.
Real cool kit, yeah.
Exactly. And finally, the really powerful counterattacks, challenging the mark itself through revocation or invalidity. And we need to get clear on why the difference between those two is so important.
Vital distinction.
Okay, let's open up the books, metaphorically speaking, and jump right in. Let's start
Yeah.
right at the beginning then. What is trademark infringement? What's the core idea we need to grab hold of first?
Okay, so at its simplest, infringement is really about stopping other people from using a sign in the course of trade, naturally,
Right.
commercially, if that sign is identical or similar to your registered trademark. And importantly, they're doing it without your permission, without your consent. It's the legal stick, if you like, that enforces those exclusive rights you get from registration. It's how you stop others from essentially riding on your brand's coattails.
Okay, so protecting those registered rights.
Mhm.
And I feel like this ties back to some things we might have covered before, like how does it connect to the functions of a trademark? We talked about that back in Chapter 10.
Oh, absolutely fundamental connection. And it's something the CJEU especially has really hammered home over the years. The extent of protection you get for your mark, it's directly linked to what the mark does
This is a
commercially.
great job.
Exactly. Its ability to guarantee origin, tell people where the goods come from, to signal quality, to act as an investment vehicle even, and its function in advertising. Infringement happens when someone else's use of a sign messes with or undermines those functions.
So the law is protecting the mark's role in the marketplace.
Precisely. It's protecting its commercial value and function.
Got it. And wasn't there also a really significant overlap with the ideas we covered in Chapter 12? On the relative grounds for refusing a registration, that's TMA Section 5, right?
Spot on. And this is a massive point if you're studying this stuff. Understanding Section 5 is, well, it's pretty much essential for getting your head around Section 10, which is the infringement section. The tests used are largely the same.
Really? The same tests.
Broadly, yes. When we're looking at infringement, we use those identical concepts. Are the signs identical or similar? Are the goods or services identical or similar? Is there a likelihood that the public will be confused?
Including association?
Including likelihood of association, yes. Or if we're talking about a mark with a big reputation, is the defendant's use taking unfair advantage? Or is it detrimental to the mark's distinctiveness or its repute? These are the Section 5 concepts applied in the infringement context under Section 10.
Wow. So basically the reasons you might have stopped someone registering a similar mark under Section 5. Those are pretty much the same reasons you'd sue them for using a similar sign under Section 10.
Exactly right. And crucially, the case law that interprets concepts like identicality, similarity, likelihood of confusion, unfair advantage, detriment, all that stuff under Section 5. It's directly applicable to infringement claims under Section 10.
So cases like Sibel, Canon, Lloyd, L'Oreal v. Ballure.
All of them. If you understand the principles from those cases in the context of relative grounds for refusal, you've already got a huge head start on understanding infringement.
That's a really useful connection to make. Now, how does this statutory right infringement compare to the common law one we looked at passing off, Chapter 11?
Passing off. That's your protection for unregistered rights, isn't it? It's about the goodwill you've built up in a name or sign through actual use in the market.
Right, the classic trinity.
Exactly. You need to prove those three things.
Yeah.
You have a reputation or goodwill in your mark, the defendant made a misrepresentation that confuses people, and you suffered damage because of it. Infringement, on the other hand, is purely based on having that registered mark.
So you don't need to prove the reputation from scratch.
No, the registration itself is your proof of rights, essentially. You just need to show the defendant's conduct fits the statutory definition of infringement in Section 10. Now, often, trademark owners will actually plead both. They'll claim infringement and passing off just in case the infringement claim fails for some reason. It's a belt and braces approach.
Makes sense. Okay, let's think about this like a typical court case, or maybe more usefully, how you'd break down an exam problem.
Yeah.
What does the claimant, the trademark owner, have to prove first? What's their job?
Think of it as the claimant building their case, yeah. They carry the initial burden. They need to establish two main things. First, they have to show that an act of infringement, something the law specifically says counts as infringing conduct, has actually happened. This is sometimes called the actus reus, the wrongful act itself. Section 10 gives us a list of these acts.
Okay, the infringing act. What's the second thing?
Second, and this is crucial, they have to prove that the defendant's conduct, that act you just identified, falls within the scope of protection of their specific registered trademark. This is where you bring in those tests we just talked about, the ones that echo Section 5.
Identity, likelihood of confusion, or the reputation stuff.
Exactly. You apply the relevant test from Section 10, 1, 2, or 3 to see if the defendant's use actually impinges on the rights granted by the registration.
So if the claimant ticks those two boxes, they show an infringing act happened, and it falls within the scope of their mark's protection. Have they basically made their case, prima facie?
Pretty much, yes. At that point, the burden shifts. The ball is in the defendant's court, so to speak.
And they have options then.
Several options. They can try to dismantle the claimant's case, argue that actually no infringing act occurred, or even if the act happened, argue it doesn't fall within the protected scope of the mark when you apply those Section 10 tests correctly.
Or they could say, okay, yeah, technically it might look like infringement, but I have a good reason for it.
Precisely. They can raise one or more of the specific statutory defenses that are laid out in the Trademarks Act, mainly in Section 11. These defenses are there to protect legitimate commercial activities, things that shouldn't be stopped.
And the most sort of aggressive response.
That's attacking the claimant's mark directly. The defendant can file a counterclaim asking the court to either revoke the claimant's registration or declare it invalid.
So they're saying your mark shouldn't even be on the register.
Exactly. Even if what I did looks like infringement, your right is flawed or shouldn't exist anymore. And as we'll see later, invalidity in particular can be an incredibly powerful weapon for the defendant.
Framing it that way, claimant's case, then defendant's responses. Deny the elements, raise a specific defense, or attack the mark itself. That seems like a really solid structure for analyzing these problems, especially for exams.
It really is. It gives you a logical flow. Identify the conduct. Is it an infringing act under the statute? Does it fall within the scope? Apply S10 tests. Does the defense apply? S11, etc. Can the mark itself be challenged? S4647. Work through it systematically.
Okay, great. Let's get specific then about those actus reus acts. What kind of behavior actually counts as infringement? You mentioned Section 10.4 mainly, but also 103.2 and 10a.
Yes, Section 10.4 gives us the main list, which comes largely from the European directive. It's worth noting the directive suggests the list isn't necessarily exhaustive, but 10.4 covers the most common infringing activities.
So what are some of the key ones on that list?
Well, pretty obvious ones first. Fixing the sign to goods or their packaging,
Yeah.
that's direct.
It's like sewing a fake label onto a shirt.
Exactly. It also covers offering goods for sale, putting them on the market, or even just stocking them for sale under the sign. Same goes for offering or supplying services under the sign.
So basically, any commercial step involving the goods or services and the potentially infringing sign.
Pretty much, yeah. All the stages of getting that product or service out there. It also includes importing or exporting goods under the sign and using the sign as or as part of a trade name or a company name.
Okay. And using it on business papers or in advertising.
Correct. That's covered too. And the final one on that list, section 10.4, is interesting. It specifically calls out using the sign in comparative advertising. If that advertising doesn't comply with the specific regulations governing comparative ads, we'll dig into that later, but basically if your comparison ad breaks the rules, using the competitor's mark in it can be infringement in itself.
You mentioned putting on the market. Is there a precise legal meaning for that?
Yeah, the CJEU looked at this in C28105 Montex Holdings Ltd v Diesel. Basically, it means the first act of making the goods available for sale or supply, either to the public or maybe to another trader. It's about that initial step that lets the goods enter the stream of commerce within the territory.
Okay. And Section 10A, that was added more recently, wasn't it?
Mm-hmm.
About goods being brought into the UK.
That's right, added by the 2018 regulations. It gives the trademark owner a specific right to prevent goods from entering the UK before they're officially released for free circulation. Think goods sitting in customs, for example. It's a tool mainly for stopping suspected counterfeits or infringing goods right at the border.
So you can stop them before they even hit the shops.
Potentially, yes. The owner can object unless the person bringing them in can prove that the owner wouldn't actually be allowed to stop those goods being sold in their final destination country anyway. It's quite a specific border enforcement mechanism.
Let's think about a more modern example. We've talked physical goods, but what about digital stuff? I remember reading about a case involving smartwatch faces.
Ah, yes, the Montrose Breguet SAV Samsung Electronics case from 2022. That was fascinating. Swatch Group, owning loads of famous watch brands, sued Samsung. The issue was digital watch faces and apps you could get on Samsung's App Store that looked identical to Swatch's famous physical watch designs.
Right, I remember that. Swatch claimed infringement of, what, loads of marks?
23 marks, yeah, including some very well-known luxury watch brands.
But hang on, if the third-party developers made the actual apps, how is Samsung potentially liable?
That was the absolute core of the case. Swatch argued Samsung wasn't just a passive platform, they were a primary tortfeasor. Why? Because of their significant involvement in control over selecting, offering, and making these apps available on their store.
So Samsung's role in the whole process.
Exactly. The court agreed that Samsung's role in the whole app process was enough to make them potentially liable for the infringement caused by these third-party apps, applying the relevant EU trademark regulation test. They found infringement had occurred in relation to some of the digital watch faces and the app names, and they noted the huge number of downloads, like 160,000 in the UK and EU alone.
Wow. So that really shows how these traditional IP principles are being applied to digital platforms and ecosystems?
Definitely. The law has to adapt.
Now, what if you're not the main infringer, but you, say, supply the labels or packaging to someone who then misuses them? Is there liability there? Secondary infringement.
Yes, that's covered by TMA Section 10.5. Importantly, this is a domestic UK provision. It's not directly from the main infringement article of the EU directive. It basically imposes liability on someone who supplies materials, think labels, packaging, business documents, advertising materials to another person.
Knowing what they'll do with it.
Knowing or having reason to believe that the trademark is going to be applied to that material in a way that constitutes infringement under Section 10.4.
So the crucial difference here, compared to primary infringement, is that knowledge element. You have to know or have reason to believe.
Absolutely. Vital distinction. For primary infringement under 10.4, you just need the act and for it to fall within the scope. For secondary liability under 10.5, the claimant must prove the supplier knew or had reason to believe the intended use was unauthorized.
And how's that knowledge judged? Is it what the supplier subjectively thought?
No, it's an objective test. The court asks, what would a reasonable person operating in that particular line of business, acting reasonably, have known or had reason to believe given the circumstances? This standard comes from LA Gear v. High Tech Sports and was confirmed in Vermont and Powell v. Bondcrest. No 2. So you're judged against the standard of your industry peers.
Okay, that covers the main acts. Does the infringing conduct have to be, like, written down or visually represented?
Good question. Section 1032 makes it clear that infringing conduct can be non-graphic. So yes, it could be oral use. For example, using someone's registered trademark without permission in a radio advert could absolutely constitute infringement.
And finally, location. Does the infringing conduct have to physically happen within the UK?
Yes, for a claim under the UK Trademarks Act, the infringing conduct generally needs to occur within the territory of the UK. This gets particularly interesting and tricky with online activities. Like, what about a website hosted in Spain that's selling goods to UK customers?
Ah, yeah, the whole online targeting issue. How do courts decide if an advert on a foreign website counts as use within the UK?
It boils down to whether the website or the advertising activity is considered to be targeted at consumers in the UK. The Court of Appeal gave guidance on this in Merck, KGaA v. Merck Sharp, and Domecor.
And it's an objective test.
Yes, assessed objectively from the viewpoint of the average consumer in the UK. The court has to look at all the surrounding circumstances.
Like what sort of things?
Things like, what language is the website in? Does it offer prices in pound sterling? Does it explicitly offer shipping to UK addresses? Is the domain name suggestive, like a .co.uk? Are there advertising campaigns specifically aimed at the UK market? Even things like customer reviews or testimonials from UK residents can be relevant. You look at the whole picture to see if the commercial activity is clearly directed towards the UK market.
So cases like Argos v. Argos applied this.
Exactly. Argos Ltd v. Argos Systems Inc. and also Easy Group Ltd v. Easy Fly Express Ltd. are examples where these principles were applied. You can't just set up shop online elsewhere and assume you're immune if you're clearly trying to attract and sell to UK customers. The internet crosses borders, and the law tries to reflect that commercial reality.
Right, the courts look at where the economic effect is felt.
Precisely. Where are you trying to reach consumers?
Okay, so we know what kinds of actions can potentially be infringing acts. But as you said, that's only half the battle for the claimant. The action also has to fall within the scope of protection of their registered mark. So when does using a sign actually infringe the rights in the mark? This is where sections 9 and 10 really bite.
Absolutely. Section 9(1) is what grants the owner the exclusive rights to use their mark. Section 10 then details when used by someone else infringes those exclusive rights. These are the core provisions defining the owner's power.
And just to hammer it home, this is where those concepts from section 5, the relative grounds for refusal, are absolutely crucial again.
Couldn't stress it enough. You must understand the tests from Section 5, because Section 10 uses the very same tests to assess identicality, similarity, likelihood of confusion, and the unfair advantage detriment aspects for marks with a reputation.
So the case law applies across both sections.
Directly. Sable, Canon, Lloyd, L'Oreal v. Ballure, all those principles are just as relevant when assessing infringement under Section 10 as they are for assessing relative grounds for refusal under Section 5.
Now, there's this key idea of trademark use. I remember the wording is slightly different. Section 9 talks about the owner's right to use the trademark, but Section 10 refers to infringing use of a sign. Did that difference cause some confusion historically?
It really did. Under the old 1938 Act, the courts often interpreted trademark use quite narrowly. It generally meant that the defendant's use had to be perceived by the public as indicating the origin of the goods.
Like the Mars v. Cadbury case.
Exactly, the treat-sized Wispa case. The court found that wasn't using the treats mark to indicate the origin of the small Wispa bars. That was the older, narrower view.
But the law shifted, mainly thanks to EU law and the CJEU.
Massively shifted. The CJEU made it very clear that while not just any commercial use of a sign is infringement, the concept of trademark use needed to be broader than just indicating origin. The critical factor is whether the defendant's use affects the essential function of the trademark.
Affects its job again.
Yes. Primarily, its job of guaranteeing origin, but also its other functions guaranteeing quality, its role in investment, its advertising function. Infringement occurs if the third party's use undermines any of these functions or takes unfair advantage of the mark's value.
So cases like Arsenal v. Reed were important here.
Hugely important. Arsenal Football Club v. Matthew Reed and also Interflora v. Marks & Spencer. They cemented this shift. While the origin function is still central, trademark use now has a much wider meaning. It protects the mark's power to, attract and keep customers, its role as a badge of origin and quality. The exclusive rights stop third-party use that undermines the proprietor's specific interests that the mark is meant to protect.
So it's not just about tricking consumers about who made it, but potentially harming the mark's value or other functions.
Precisely. And the CJEU in C1706 Celine, v. Celine SA, the Celine case, helpfully laid down 4 definitive conditions that must all be met for there to be infringement under EU law. If you're analyzing infringement, these are your absolute go-to checklist points.
Okay, what are they?
1, the use must be in the course of trade. 2, it must be without the consent of the proprietor. 3, it must be in respect of goods or services. And 4, the crucial one, it must affect, or be liable to affect, the functions of the trademark, in particular its essential function of guaranteeing origin.
Okay, without consent seems straightforward enough. Let's quickly touch on the others. Use in the course of trade.
Yeah, we mentioned this briefly. It means use in a commercial activity with a view to economic gain, not just purely private use. The TravelX case, T19500, where the EU Commission adopted the euro symbol that wasn't seen as use in the course of trade because it wasn't a commercial supply. Electrocoin Automatics v. CoinWorld found incidental letters on a gaming machine display weren't used in the course of trade. The phrase from RxWorks v. Hunter sums it up. With a view to gain and not as a private matter.
Right. And use in respect of goods or services. How do we know if a sign is used in relation to something?
This asks if the sign is being used to identify or distinguish those specific goods or services, or if it's just sort of there, incidentally. Remember Trevor Bassett v. the Football Association? The football badge inside the sweet wrapper wasn't seen as being used in relation to the sweets themselves.
It just happened to be there.
Exactly. Contrast that with Butamatic v. Mitchell, where using the mark on invoices was clearly used in relation to the goods being invoiced. Arsenal v. Reed is useful again here. Ask why is the defendant using the sign? Is it to help sell their goods? That points strongly towards use in relation to those goods, and also hints at potentially misappropriating the mark's value.
Okay. And that crucial 4th Celine condition, affecting functions.
Yes.
How do we figure that out? Through the consumer's eyes.
Yes, exactly. It's assessed from the perspective of the average consumer for those particular goods or services. We talked about the average consumer a lot back in Chapter 12, didn't we?
We did. Reasonably well-informed, observant.
That's the one. Think about C4805 Adam Opel AGV Autek, the toy car case. The question was, does the average consumer see the Opel logo on the toy car as indicating the origin of the toy, or just as a detail making the model look authentic? If they just see it as part of making the model look real and don't think Opel made the toy, then the mark's origin function for the toy isn't affected. Compare that to Arsenal v. Reed, where people buying scarves with the Arsenal crest did see the crest as indicating the club guaranteed the goods. It's all about consumer perception.
This affecting functions test seems especially relevant for the whole AdWords and search engine keyword issue. How does infringement law handle traders using competitor marks as keywords?
Ah, yes, the AdWords saga. This has been a huge legal battlefield. The scenario is Trader A bids on Trader B's trademark, or something very similar, as a keyword. So when someone searches for Trader B's brand, an advert, a sponsored link for Trader A's business pops up.
Right, it seems dodgy.
Well, the CJEU tackled it in C23608, Google France v. Louis Vuitton. First, they said Google itself, by just providing the AdWords platform, wasn't using the trademarks in the relevant sense. But the advertiser situation is different.
Yep.
The court said if the sponsored advert that appears makes it difficult for the average internet user to easily tell whether the advertised goods or services come from the trademark owner or someone else completely unconnected, then it is liable to create the impression of a material link. And that undermines the mark's distinguishing function. That equals infringement. The national court then has to look at the specific ad and decide.
So it all hinges on how the ad looks and whether it confuses the average user about origin or connection.
Exactly. C55808 Portakabin Ltd v. Primakabin BV drove this home. Assessing trademark use in the AdWords context depends entirely on whether that average consumer perceives an economic link between the advertiser and the owner of the trademark they searched for.
What about online marketplaces like eBay?
C32409 L'Oreal SAV eBay added layers. An operator like eBay can be stopped from using a sign in its own referencing service ads. Like if eBay bids on L'Oreal to bring people to its site, if that ad makes it hard to tell the origin of what's being advertised. But importantly, eBay isn't considered to be using the trademarks that simply appear within the listings posted on its site by independent sellers. That's the seller's use, not eBay's.
Okay. And Interflora v. Marks & Spencer, that was directly competitor versus competitor using keywords, wasn't it?
Yes. C32309. The court said a competitor using the claimant's mark as a keyword can be stopped if that use is likely to adversely affect one of the mark's functions. Bidding on Interflora and showing an M&S Flowers ad, that's likely to affect the origin function, confusion, and potentially the investment function, free riding on Interflora's brand billing, though probably not the advertising function itself. The court suggested this kind of use would likely infringe under both Section 10.1 if identical, and especially Section 10.3 as Interflora has a reputation.
And we've seen follow-up cases like Cosmetic Warriors v. Amazon and Victoria Plum v. Victorian Plumbing. In Victoria Plum, didn't the court find infringement because the defendant's ad didn't make the origin clear?
Correct. The High Court found that Victorian Plumbing's advert, triggered by bidding on Victoria Plum, did not allow users to easily ascertain that the advertised services came from Victorian Plumbing and not Victoria Plum. Therefore, it affected the origin function and was infringement.
So the clear principle is, if your online ad, triggered by a competitor's mark, muddies the waters about who's offering the goods or services, you're probably infringing.
That's the gist of it, yes. Clarity for the consumer is paramount.
That makes sense. And speaking of online context, you mentioned some recent cases emphasizing how the specific environment matters for confusion.
Yes, exactly. Cases like Iconics v. Dream Pairs and Prysmian Cables v. MS Apple, both from 2023, really highlight this. In Iconics, it involved football boots sold on Amazon. The defendant's brand name was somewhat similar to Iconics' Umbro mark.
But the court found no confusion.
Right. Despite some similarity in the marks themselves, the court looked closely at the local context specifically, how the product was presented on the Amazon Marketplace page.
What was it about the Amazon page that made the difference?
Well, the court considered the combination. The similarity between the marks themselves was actually quite low, plus the way the product was displayed. Critically, the defendant didn't use the name Umbro anywhere in their listing. There was no suggestion of any link to Iconics or Umbro. The court decided that an average consumer shopping on Amazon, seeing that specific listing in its context, wouldn't likely be confused about who made the boots or if there was a connection.
So it shows that how and where you use a sign is just as important as the sign itself.
Absolutely. It can make the difference between infringement and non-infringement, even if the signs have some similarities. The surrounding environment shapes consumer perception. That's a really key practical takeaway, especially for online businesses.
Definitely. Presentation matters hugely.
Hugely.
Right.
Now, when you're pulling all this together, especially if you're tackling an exam question, it's vital to apply the different parts of Section 10 methodically. We often talk about the triad of protection.
And you apply them in order, right? Section
Yep.
10, 1, then 2, then 3, just like we did with Section 5.
Yes, exactly that order. It's the recommended approach, reinforced in cases like read executive v. read business information. You start with the highest level of protection, the most straightforward, Section 10.1. Identity. This is the double identity rule. It applies if the defendant uses a sign that is identical to the registered mark and uses it in relation to goods or services that are identical to those covered by the registration.
And if both are identical.
Then it's absolute infringement. You don't need to prove any likelihood of confusion. The case LTJ Diffusion confirmed identical means the differences are so insignificant they'd go unnoticed by the average consumer. It's a simple comparison.
Okay, so if it's not double identity, you move down to Section 10.2.
Correct. Section 10.2. Similarity and likelihood of confusion. This covers situations where the sign used by the defendant is identical or similar to the registered mark. A and D, the goods or services, are identical or similar. But here, identity or similarity alone isn't enough. The claimant must prove there's a likelihood of confusion for the public. And the Act specifically says this includes the likelihood of association.
Right, and this is where you weigh up all those factors, how similar the marks look, sound, mean conceptually, how similar the goods services are, how strong the original mark is.
Exactly. This is probably the most common ground for infringement, and it's highly fact-dependent. You apply all those principles from the Section 5.2 case law we mentioned, the Global Appreciation Test, SIGL, the interdependence principle, CANA meaning greater similarity between marks can offset lesser similarity between goods and vice versa, considering the distinctiveness and reputation of the earlier mark, and remembering that likelihood of association isn't a separate test, but part of the confusion assessment. Lloyd, you're asking. Is the average consumer likely to be mistaken about the commercial origin?
Okay, and if that doesn't apply, or in addition, you consider Section 10.3, the protection for famous marks.
Yes, Section 10.3. Protection for marks with a reputation. This offers broader protection. It applies if the defendant uses a sign that's identical or similar to a registered mark which has a reputation in the UK. Now, the really big difference here is that the defendant's use can be in relation to any goods or services, even if they are completely dissimilar to those the mark is registered for.
So using a famous car badge on, say, T-shirts, even if the car company doesn't make T-shirts.
Potentially, yes. For this section to apply, the claimant has to prove three things. One, their mark has a reputation in the relevant territory, the UK. Two, the defendant's use is without due cause. And three, that use either takes unfair advantage of the distinctive character or repute of the mark, often called free riding or parasitism, or is detrimental to the distinctive character of the mark known as blurring or dilution, where the mark's ability to uniquely identify the owner's goods is weakened, or is detrimental to the repute of the mark known as tarnishment, where the use harms the positive image or prestige of the mark.
So this goes way beyond confusion about origin. It's about protecting the mark's inherent value, its selling power, its image from being unfairly exploited or damaged, even on totally unrelated products.
Exactly. Cases like Intel help define blurring and tarnishment, while L'Oreal v. Velour is absolutely key for understanding unfair advantage, or free riding essentially, getting a commercial boost by linking your product to the positive image of the famous mark without justification.
But it's not automatic protection just because a mark is famous.
No, definitely not. The claimant still needs to provide evidence showing that one of those specific types of harm, unfair advantage, blurring, or tarnishment, has actually occurred or is seriously likely to occur. It gives owners of well-known marks powerful extra protection, but they still have to prove their case under these specific heads.
Right. So working through 10.1, then 10.2, then 10.3, that's the clear roadmap for figuring out if the defendant's use falls within the scope of protection.
That's the systematic way to do it.
Fantastic. Okay, we've really mapped out how a claimant builds their infringement case. Now let's flip the script entirely. What can a defendant do to push back? This brings us squarely to the defenses, particularly the statutory ones in sections 11 and 48 of the TMA.
Right. So as we sketched out earlier, the defendant's first line of defense is always to try and poke holes in the claimant's case. Argue that, no, there wasn't actually an infringing act according to the law, or even if there was an act, it doesn't fall within the scope of protection based on those Section 10 tests in the case law we just discussed.
Deny the core elements.
Exactly. But let's assume the claimant has established those elements, at least prima facie. The defendant isn't necessarily sunk. They can then rely on specific statutory defenses. And of course, they have the option of that counterattack, seeking revocation or invalidity of the claimant's mark.
Let's start with defenses that seem almost built into the definition of infringement itself.
Good place to start. Those are consent and non-trademark use. Remember, Section 9.1 gives exclusive rights without the consent of the proprietor. So, pretty simply, if the trademark owner actually consented to the defendant's use, it's not infringement. Full stop. The Northern and Shell v. Condé Nast case is an example. One licensee, using the mark with the owner's permission, couldn't be sued by another licensee. Consent is a complete defense.
Okay, and the other one, non-trademark use.
This goes back to that crucial fourth condition from the Celine case. The defendant can argue that their use of the sign, even if it's identical or similar, simply wasn't trademark use in the legal sense. They argue that, viewed objectively through the average consumer's eyes, their use doesn't affect or isn't liable to affect any of the mark's functions, origin, quality, investment, advertising, etc.
So even if the signs look alike, if the way the defendant used it doesn't interfere with the mark's job,
then it doesn't meet the threshold for infringement established by the CJEU in cases like Arsenal and Celine. It's arguing the use falls outside the scope of what the law intends to protect.
Okay, what about Section 11? That's a specific defense where the defendant is using their own registered trademark.
Yes, exactly. This defense applies in the slightly awkward situation where, for whatever reason, two potentially conflicting marks have ended up on the register. The owner of the earlier mark sues the owner of the later mark for infringement. The defendant's response is, hang on, I'm just using the mark that I have registered.
And the owner of the earlier mark, they maybe could have opposed the later registration or tried to get it invalidated.
Precisely. And they can still try to get the junior mark invalidated under Section 47, arguing it breached Section 5 when it was registered because of their earlier rights. But that route, as we'll see, is subject to time limits under Section 48 acquiescence. So Section 11.1 operates on the assumption that right now both marks are validly on the register.
What's the catch for the defendant using this defense?
The absolute crucial condition for the Section 11(1) defense to work is that the defendant must be using their junior mark exactly in the form in which it is registered, any significant variation, and the defense fails.
Like the Neutrogena case.
That's the classic example. Neutrogena v. Golden Ltd. The defendant's registered mark was Neutralia, but they were actually using the sign Neutralia. The court said Neutralia was different enough from the registered mark Neutralia that the Section 11(1) defense didn't apply. It's a very strict requirement. Use it as registered or lose the defense.
Got it. Okay. Section 11(2) then. This introduces a set of 3 really key defenses, often seen as protecting fair competition, right? And you mentioned they all share a crucial condition.
Yes, these 3 defenses come from Article 6 of the EU directive. They're really important protections for legitimate activities by other traders, but critically, all 3 are subject to the overriding proviso that the defendant's use must be in accordance with honest practices in industrial or commercial matters.
Okay, let's take them one by one. First, Section 11(2)(a), using your own name and address.
Right. Now, historically, this defense applied to both individuals using their personal name and companies using their registered trading name. You had cases like Hotel Cipriani or Reed Executive v. Reed Business Information, where companies relied on this. However, and this is a really, really critical update you need to know stemming from the 2015 directive and brought in by the 2018 UK regulations, this defense was significantly changed.
How so?
Section 11(2)(a) now only applies to the use by an individual, a natural person of their own name and address. Corporate bodies, companies cannot rely on this specific defense anymore.
Wow, okay. That's a huge restriction. So a company called, say, Smith Services Ltd. can't automatically rely on the own name defense if there's an earlier Smith's trademark.
Not under Section 11(2), no. They'd have to argue their use doesn't infringe for other reasons. Even G, no likelihood of confusion, not trademark use. Or look for other defenses. But the specific statutory own name defense is now off the table for companies. That's a major shift from the older case law.
Definitely one to remember. What's the second defense in Section 11(2)?
Subsection B.
Section 11(2)(b) is the descriptive use defense. This allows a trader to use signs or indications which are not distinctive in themselves or which serve to describe characteristics of goods or services.
Like what kind of characteristics?
Things like the kind, quality, quantity, intended purpose, value, geographical origin, or the time of production or rendering of the service. Basically using ordinary descriptive words. So if someone somehow managed to register the word sharp as a trademark for pencils, could a competitor still advertise their pencils as being sharp?
Yes, exactly. That's the purpose of this defense. You are allowed to use the claimant's registered mark if you are using it purely descriptively to accurately describe characteristics of your own goods or services. The example often given is if Baby Dry is registered for diapers, a competitor can still use the phrase guaranteed to keep your baby dry in their advertising because dry is being used descriptively for their own nappies.
Right, using it as a normal adjective, not as a badge of origin for your product.
Precisely.
And the third defense in Section 11(2), subsection C.
This is about using the trademark to indicate the intended purpose of a product or service. Specifically, it allows you to use the trademark owner's mark to identify or refer to the proprietor's goods or services when doing so is necessary to indicate the intended purpose of your own product or service. Think accessories or spare parts.
Like saying, these brake pads are suitable for F4E cars. Or a garage advertising, we specialize in servicing BMWs.
Exactly those kinds of uses. You're using the Ford or BMW mark to explain what your product, brake pads, or servicing, is designed for in relation to the trademark owner's goods.
What does necessary mean in that context? Does it have to be literally the only way?
The CJEU looked at this in C 2002-803, the Gillette Company v. LA Laboratories, OI. Necessary essentially means that, practically speaking, there isn't another effective way for the defendant to communicate the compatibility or intended use of their product to the relevant consumers. If you need to use the bland name so people understand what your spare part fits, that's likely necessary.
Okay, so those were the 3 core Section 11(2) defenses. Own name, now only individuals, descriptive use, and indicating intended purpose. But you stress they're all subject to that honest practices condition. How does that work?
This is the big gatekeeper for all 3 defenses. The use, whatever it is, must be in accordance with honest practices in industrial or commercial matters. This principle actually has roots in Article 10(b) of the Paris Convention, which deals with unfair competition generally.
And how do courts assess if something is honest practice? Is it about the defendant's state of mind?
Not primarily. It's judged objectively. The court looks at the defendant's likely motives and all the surrounding circumstances of the use, but assesses it objectively. Would a reasonable business person in that sector consider this conduct fair? Scandicore Development, ABV Scandicore Marketing AB, confirmed this objective approach.
Has the CJEU given guidance on what counts as not honest?
Yes, quite a bit. In C6397 BMW v. DNIC, the BMW service IDs, the court said even if using the mark is necessary for intended purpose, the defendant must act fairly. They shouldn't create a misleading impression of a commercial connection or approval from the trademark owner, and the use shouldn't tarnish the mark's image. There's a general duty to act fairly in relation to the legitimate interests of the trademark owner, a phrase repeated in C1002 Gerolsteiner Brennan v. Putsch and picked up in UK cases like Reed Executive.
And the Gillette case added more specific benchmarks for dishonesty.
Yes, C228U3 Gillette gave a useful, though not exhaustive, list of factors indicating practice might not be honest. It's likely not honest if the use 1. Gives the impression of a commercial connection, like sponsorship or endorsement, between the defendant and the trademark owner. 2. Takes unfair advantage of, or is detrimental to, the mark's distinctive character or reputation. 3. Discredits or denigrates the trademark. 4. Presents the defendant's product as an imitation or replica of the product bearing the trademark.
So if the defendant's conduct ticks any of those boxes, their Section 11(2) defense is likely to fail because it's not considered honest practice.
That's exactly right. The honest practices condition acts as a fundamental check to ensure these defenses protect fair competition, not unfair exploitation or misleading conduct.
Can you give a couple of quick examples where a defense failed because the use wasn't honest?
Sure. In AB Volvo v. Heritage, Leicester Ltd., the defendant used headed paper that strongly implied they were still an authorized Volvo dealer when they weren't. That failed the honest practices test for their intended purpose name defense.
Deceptive.
Yes. IBM Corporation v. WebSphere Ltd. was an older own name case where the defendant company deliberately changed its name to WebSphere just as IBM was launching its major WebSphere software product. The timing and context made it clear they were trying to take unfair advantage, so not honest practice. And in Hasbro Inc. v. 123 Narmiddle GmbH, using Play-Doh descriptively for sweets, failed because the court felt the defendant's overall conduct was aimed at unfairly associating with Hasbro's famous Play-Doh mark.
What about AdWords? Using competitor marks as keywords, does honest practices come into play there regarding Section 11(2)?
The CJEU in Portakabin v. Primakabin, C55808, suggested it's actually unlikely that the Section 11(2) defenses, like descriptive use or intended purpose, would be available for using competitor marks as AdWords. Why? Because such use often inherently fails the honest practices test by creating confusion or taking unfair advantage. Although, as always, the final decision rests with the national court on the specific facts.
So the Section 11(2) defenses look helpful on paper, but that honest practices requirement is a really significant hurdle for defendants to overcome.
It absolutely is. It ensures these defenses are used appropriately, balancing the defendant's freedom to trade with the claimant's legitimate rights.
Okay. Are there any other general defenses we should cover besides those in Section 11(2)?
Yes, a couple more important ones. Section 11(3) provides a defense for the owner of an earlier right, which could be an unregistered right like passing off, that is valid only in a particular locality. This is sometimes called the prior local right defense.
So protecting small local businesses who were using a name before someone else registered it nationally.
Exactly. It allows them to continue using their right in that specific locality, even against a later national registration. And their argument is basically, we were here first in this area.
Okay. And then there's Section 48 acquiescence. What's that about?
Acquiescence under Section 48 is quite specific. It arises when the owner of an earlier registered trademark has knowingly tolerated the use of a later registered trademark for a continuous period of 5 years.
Knowingly tolerated. So they knew about the later mark and its use and didn't object.
Yes, they knew it was registered and knew it was being used and let 5 years pass without challenging it based on their earlier right.
What's the consequence? Does the later mark get canceled?
No, usually not. This is statutory acquiescence, and its effect is limited. If the conditions are met, the owner of the earlier mark loses the right to apply for a declaration that the later mark is invalid based on the earlier mark. They also lose the right to oppose the use of the later mark in relation to the goods services for which it has been used.
So it creates a kind of stalemate. Both marks stay on the register.
Essentially, yes. It leads to forced coexistence. It assumes both marks are on the register, much like the Section 11(1) defense. It prevents the earlier owner from attacking the later mark after 5 years of knowing tolerance, but it doesn't typically remove the later mark. It's different from equitable acquiescence principles.
Right, a very specific statutory rule for registered versus registered situations.
Yeah.
You also mentioned honest concurrent use earlier. Is that a statutory defense?
No, it's not listed as a specific defense in the TMA or the directive like Section 11 ones, but it's a principle that UK courts and the CJEU have acknowledged can be relevant. Mr. Justice Carr discussed it in Victoria Plum Ltd v. Victorian Plumbing Ltd.
What's the principle?
It's the idea that sometimes two different businesses might have honestly used the same or very similar names in the same field for a long time, perhaps developing goodwill independently. In such cases, a certain amount of confusion might just be inevitable due to the historical coexistence.
And the law might just have to accept that inevitable confusion.
It might, yes.
Hey,
The CJU touched on this in C48209, Buda Vikibig Budvar NPV and Horser-Busch Inc. If the mark has come to signify the origin of either business in the minds of consumers, not just the claimant, then the claimant's origin function isn't necessarily impaired just because the mark doesn't only point to them.
but there's a catch, presumably.
Oh, definitely. The defendant relying on honest concurrent use must not do anything to actively worsen the confusion beyond what's inevitable from the historical overlap. They can't try to deliberately encroach on the claimant's goodwill. In the Victoria Plum case, for example, Victorian Plumbing couldn't benefit from this principle because they were actively bidding on Victoria Plum as an ad word, which the court saw as going beyond honest coexistence and deliberately increasing confusion.
So passive coexistence might be tolerated, but actively stirring the pot is not okay.
That's a good way to put it. Honest concurrent use requires, well, honesty in the ongoing use.
Okay, let's switch gears to a very specific context where competitor marks are often used. Comparative advertising. How does trademark law handle that? It's mentioned in Section 10 core, and there are specific directives, right?
Yes, comparative advertising is where a business explicitly or implicitly compares its products or services with a competitor's, often naming the competitor or their brand. Think wash is whiter than Persil type ads.
Attitudes towards this vary, don't they?
They do. Some jurisdictions see it more as potentially unfair free riding on the competitor's reputation, while others, particularly in the UK, view it more positively as providing useful information for consumers, as long as it's fair and accurate.
And UK law on this has changed over time?
Significantly. Under the old 1938 Act, using a competitor's registered mark in an ad was almost always treated as infringement, sometimes trade libel too. Cases like Bismag, Chanel, Compaq reflected this stricter approach. The 1994 TMA tried to liberalize things a bit with the specific defense, Section 10(6), now repealed, leading to battles like British Airways v. Ryanair.
So what's the rule now?
The current law is a combination of the EU Trademarks Directive, as amended in 2015, and the specific EU Comparative Advertising Directive. The CAD, codified as 2006-114 EC. In the UK, the CAD rules are implemented mainly through the Business Protection from Misleading Marketing Regulations 2008. While bodies like the Advertising Standards Authority, AS, often handle complaints about misleading ads, using a competitor's trademark in an ad can still lead to an infringement action.
So what makes comparative advertising acceptable under these rules so it doesn't infringe?
The CAD sets out a list of strict conditions. To be permissible, comparative advertising must meet all of these. It must not be misleading. It must compare goods or services meeting the same needs or intended for the same purpose. It must objectively compare one or more material, relevant, verifiable, and representative features, which can include price. It must not create confusion in the marketplace between the advertiser and the competitor, or between their respective trademarks or names. It must not discredit or denigrate the competitor's trademarks, names, goods, services, or activities. And, very importantly, it must not take unfair advantage of the reputation of a competitor's trademark or name.
That's quite a checklist. So if an ad meets all those conditions,
Then it's generally okay. The CJEU confirmed this in C533-602 Holdings, Ltd v. Hutchinson 3G UK Ltd. They said the Trademarks Directive and the CAD must be read together. Using a registered trademark in comparative advertising that complies with all the conditions of the CAD will not constitute trademark infringement. Compliance with the CAD effectively provides a defense to an infringement claim.
so follow the CAD rules, and you're safe from an infringement suit for using the mark in the ad. What if the ad doesn't comply?
then the opposite applies, especially after the 2015 amendments to the Trademarks Directive. Using a registered trademark in comparative advertising in a manner that does not comply with the conditions set out in the CAD will constitute trademark infringement. This is now explicitly stated as an infringing act under TMA Section 10(4).
Okay. And what about ads that present the advertiser's product as an imitation or replica of the competitors, like smell like perfumes?
C48707, L'Oreal SAV Ballure NV, dealt with exactly that. The court held that presenting goods as imitations or replicas of a product bearing a protected trademark, often done using comparison lists linking the cheap version to the famous brand, falls outside the protection offered by the CAD. It's not considered legitimate comparison. Furthermore, the court said the advantage gained from such unlawful comparative advertising constitutes unfair advantage under the Trademarks Directive, potentially leading to infringement under Section 10(3) if the competitor's mark has a reputation.
So comparison is allowed, but imitation claims are not, and breaking any CAD rule makes the use infringing.
That's the essence of it. You can compare, but you have to play fair according to the strict CAD rules.
Right. Another crucial area, especially relevant for businesses dealing with international trade, is the doctrine of exhaustion of rights. What exactly is this, and how does it function as a defense? This involves TMA Section 12 and Article 7 of the directive, doesn't it?
Yes, exactly. Exhaustion of rights is a defense that comes up specifically in the context of imported goods bearing a trademark. Remember, importing goods under the sign is listed as a potential infringing act in Section 10(4). So the doctrine of exhaustion provides a potential defense for the importer and also for anyone who subsequently deals in those imported goods.
Why does this doctrine exist?
Its origins lie in EU law, specifically the need to reconcile the territorial nature of intellectual property rights, like trademarks, which are granted country by country, with the fundamental EU principle of the free movement of goods within the single market, guaranteed by Articles 34 and 36 of the Treaty on the Functioning of the European Union, TFEU.
So it's a balancing act.
Precisely. It balances the trademark owner's right to control the first time their goods are put on the market within the territory against the interests of traders and consumers in having those goods circulate freely after that first sale. The rules were transposed into Article 7 of the Trademarks Directive and Section 12 of the UK's TMA. Similar principles apply to other IP rights like patents and copyright. And importantly, the UK initially retained this EU-based exhaustion regime post-Brexit via regulations in 2019.
Okay, and this leads to the absolutely critical distinction between parallel imports and infringing goods.
That's the core distinction you need to grasp. The first crucial question is, who first put the specific batch of goods in question into circulation within the European Economic Area, EEA?
Okay, what if it was the trademark owner or someone they allowed?
If the goods were first put on the market anywhere within the EEA, either by the trademark owner themselves or by someone else acting with their consent, like a subsidiary company, an official licensee, or an authorized distributor, then those goods are considered parallel imports or gray market goods.
And what does that mean legally?
It means the trademark owner's rights in relation to those specific goods are considered exhausted throughout the EEA. They cannot use their trademark rights in, say, the UK to stop those goods from being imported from, say, France or from being resold within the UK. Their right to control the distribution of those particular items ended with that first authorized sale within the EEA. Trying to stop them would be seen as an unlawful, disguised restriction on trade under TFEU Article 36.
So once sold with permission inside the EEA, they can move freely. What if they were put on the market by someone else entirely?
If the goods were put on the market by an unconnected third party, typically a counterfeiter making fakes, or maybe even a competitor somehow getting hold of them, those are infringing goods. In this case, the trademark owner can fully rely on their national trademark rights to prevent the import and sale of those goods. Their rights are not exhausted because they never consented to those goods entering the market.
Okay, that covers goods first sold inside the EEA. What about genuine goods that the trademark owner first sold outside the EEA, say in the USA or China? Can those be freely imported into the UK?
This is the multi-million-dollar question and the source of major legal battles. The CJEU delivered a landmark and quite controversial ruling on this in C35596, Silhouette International v. Hartlauer.
What did Silhouette decide?
It ruled that there is no doctrine of international exhaustion recognized in EU trademark law. EU member states must apply only intra-EEA exhaustion. This means if genuine goods are first put on the market by the trademark owner outside the EEA, the owner can generally use their EEA trademark rights to prevent those goods from being imported into and sold within the EEA, even though they are genuine products.
Wow. So even if they're authentic Nike trainers first sold by Nike in the US, Nike's European arm could potentially stop someone importing them into the UK to resell them.
That's the general consequence of the silhouette ruling and the principle of EEA-only exhaustion, which, as mentioned, the UK initially maintained post-Brexit. The UK is still considering its long-term approach here, but the EU position is clear.
What's the key factor then for exhaustion within the EEA?
Consent. It all hinges on whether the goods were put on the market within the EEA with the consent of the trademark proprietor. Consent is an EU law concept, and Article 7 of the directive makes it the decisive factor.
How is consent proven, especially for goods originating outside the EEA?
The key case here is C41499 Zeno Davidoff SAV A&G Imports Ltd. and parallel cases. This case firmly rejected arguments for implied international exhaustion and set a high bar for proving consent. Consent must be unequivocally demonstrated. Usually this means express consent. Crucially, consent is not implied merely from the owner's silence, or from them not putting warnings on packaging, or not including export restrictions in their sales contracts outside the EEA. The burden of proof is squarely on the importer to show that the trademark owner unambiguously consented to those specific goods being marketed within the EEA. It's tough to prove.
So if you're importing genuine branded goods from outside the EEA, you need really solid proof that the brand owner actually agreed to them being sold here.
Absolutely. Without that clear, unequivocal consent, the trademark owner can likely block the imports using their EEA rights. The court used various legal concepts to justify this, like distinguishing the existence of the right from its exercise and protecting the specific subject matter or essential function of the trademark, which includes controlling the first placing on the EEA market.
Got it. Now, how exactly is put on the market within the EEA defined? Does just bringing them into a warehouse count?
No, simply storing them isn't enough. C1603 Peak Holding ABV Axel and Eleanor AB clarified it generally requires an actual sale, either to the public or to another trader who then has the power to dispose of the goods. Merely displaying goods without offering them for sale or holding them in transit doesn't usually trigger exhaustion. Class International BVV Colgate-Palmolive found transit warehousing didn't count. Also, if goods are supplied under conditions where ownership doesn't really transfer, like free samples marked not for resale, that's generally not considered being put on the market. Coty, Prestige v. Simex Trading, L'Oreal, SAV, eBay.
Okay. What about altering the goods after import? Like, importers often need to change the packaging for the local market, right? Putting instructions in English, for example, doesn't that interfere with the trademark?
Yes, it absolutely does. Prima facie, any repackaging, rebranding, relabeling, or even just over-stickering imported goods that bear someone else's trademark is an act of infringement. You're altering the state in which the goods were marketed.
But isn't there an exception? Especially for things like pharmaceuticals.
There is. This is where Article 7.2 of the directive and Section 12.2 of the TMA comes in. It provides a crucial exception developed through extensive CJEU case law, primarily the Hoffman-La Roche and Boehringer I and Boehringer II cases. These cases established a very strict set of cumulative conditions that a parallel importer must satisfy if they want to repackage or relabel the goods and still benefit from the exhaustion defense. While developed largely for pharma, these rules apply to all types of goods.
Okay, cumulative conditions meaning the importer has to meet all of them.
Every single one. Fail on one, and the defense fails.
Right. Lay them out for us. What are these Boehringer conditions for repackaging, relabeling?
Okay, there are essentially 5 core requirements. 1. Necessity. The repackaging or relabeling must be objectively necessary to allow the product to be marketed in the importing member state. And crucially, this necessity must generally arise because the trademark owner's own actions have artificially partitioned the internal market, for example, by using different pack sizes, languages, or even different brand names for the identical product in different member states. It can't just be for the importer's convenience. 2. No physical impairment. The repackaging or relabeling must not affect the original condition or quality of the product inside the packaging. You can't damage the goods. 3. Clear identity. The new packaging or label must clearly state who carried out the repackaging, relabeling, and also the name of the original manufacturer. This transparency is vital so consumers aren't misled about responsibility. 4. No damage to reputation, mental impairment. The presentation of the repackaged or relabeled product must not be liable to damage the reputation of the trademark or its owner. This includes the physical appearance. The packaging can't be defective, poor quality, or untidy. It also covers the mental aspect. It shouldn't undermine any aura of luxury associated with the mark. Parfums Christian Dior v. Evora BV. 5. Notice and samples. The importer must give prior notice to the trademark owner before the altered goods go on sale, and if the owner requests it, the importer must supply them with a sample of the repackaged or relabeled product. Wellcome Foundation v. Paranova gives more detail on the notice requirements.
Wow, that is a very high bar for parallel importers wanting to repackage. They need to justify necessity, protect the product, be transparent, protect the brand image, and give notice.
Exactly. And remember, the burden of proof is entirely on the importer to demonstrate that they have satisfied all 5 of these conditions.
That seems like a significant protection for brand owners against potentially damaging repackaging. What about other alterations, like refilling containers?
Interesting one. In C4610 Viking Gas AS v. BP Gas AS, the CJEU found that merely refilling imported gas canisters that already bore the BP mark was not considered infringement under these rules.
And people selling or servicing these parallel imported goods, can they advertise using the mark?
Yes, those who legitimately resell or repair goods whose rights have been exhausted can generally refer to the trademark. But they still need to be careful, particularly under that honest practices proviso we discussed earlier, and also under the exhaustion rules themselves. They must avoid conduct that could cause mental impairment by tarnishing the mark's image or falsely implying an economic connection, as seen in Parfums Christian Dior v. Evora BV, perfume ads, and BMW v. Denick, independent repairers.
Okay, one last bit on exhaustion. How does it interact with trademarks that have been assigned, sold to different owners in different countries, or licensed out?
This area caused a lot of confusion in the early days of EU law. Cases like Serena and Hague, I seem to suggest that if marks had a common origin historically, owners couldn't necessarily stop imports, even if the marks were now owned by different competing companies.
But that approach changed.
Yes, thankfully. Later cases, particularly Hague 2 and IHT International Heisstechnik, clarified the position. The current rule aligns with the general exhaustion principle. It all comes down to consent to marketing within the EEA. So, if a trademark has been assigned to different owners in different EEA countries, imports from goods marketed by one assignee can generally be stopped by the owner in another country because the original owner or the current owner hasn't consented to that assignee's goods being marketed across the border. However, imports of goods marketed by a licensee generally cannot be stopped, provided the original trademark owner consented to that licensee putting the goods on the market within the EEA in the first place. Consent is the overriding EU concept.
What happens if a licensee breaks the rules of their license agreement? Does that affect exhaustion? Say they sell poor quality goods.
This was tackled in a very significant case, C5908 Copad SAV Christian Dior Couture SA. The CJEU delivered a powerful ruling strengthening brand owners here. They said that the owner's consent to marketing may be treated as withdrawn if the licensee breaches certain important provisions in the license agreement, particularly quality control provisions.
Why quality control specifically?
Because it directly impacts the quality guarantee function of the trademark. If a licensee puts substandard goods onto the market in breach of the license's quality clauses, those goods are considered to have been marketed without the proprietor's consent. Therefore, Article 7.1, the exhaustion principle, does not apply to those goods. The owner can then use their trademark rights to oppose the further sale and distribution of those substandard items.
So a breach of quality control by a licensee isn't just a breach of contract. It can actually revive the owner's trademark rights to stop those goods circulating.
Exactly. Copad even went further, suggesting that if a licensee breaches other terms, like selling luxury goods to unauthorized discount retailers, and this breach damages the mark's image or aura of luxury, the owner might be able to oppose further commercialization under Article 7.2, the damage to reputation exception to exhaustion, even if the goods themselves were initially put on the market with consent.
That's a really important clarification, linking license terms directly back to infringement and exhaustion rights based on the mark's functions.
It really reinforces the importance of those functions.
Right. We have thoroughly explored the ways a defendant can defend against an infringement claim, arguing the elements aren't met, raising specific defenses like Section 11, or relying on exhaustion. But you mentioned they can also go on the attack, challenging the claimant's registration itself. This brings us to revocation and invalidity under TMA Sections 46 and 47.
Yes, these are the mechanisms for getting a registered trademark removed from the register entirely, and they are very commonly raised as counterclaims in infringement proceedings. It's basically the defendant saying, your infringement claim is based on this registration. Well, that registration shouldn't be there anyway.
Who can apply for these? Does the defendant need a special interest?
Generally, for most grounds of revocation and invalidity based on absolute grounds, like the mark being descriptive, any person can apply. You don't need a specific commercial interest. The exception, as we'll see, is for invalidity based on relative grounds, conflict with an earlier right, where only the owner of that earlier right can apply.
Okay, let's start with revocation under Section 46. What's the underlying reason for revoking a mark?
Revocation is all about post-registration problems. It deals with issues arising after the mark has been successfully registered, usually due to the owner's actions or inaction.
And what's the effect if a mark is revoked? Does it wipe out past infringement?
No, and this is a absolutely critical difference compared to invalidity. If a mark is revoked, it's typically removed from the register prospectively, meaning its effects are canceled for the future, usually from the date the revocation application was filed, though the court can set a different date. It does not operate retrospectively. Therefore, revocation does not exonerate the defendant from liability for any infringement that occurred before the date of revocation.
So it stops future claims, but doesn't help with past damages. Got it. What are the main grounds for revocation in Section 46?
There are four main grounds. The first two, and probably the most common, relate to non-use. 1. Section 46, 1A. The mark has not been put to genuine use in the UK for a continuous period of 5 years, starting from the date the registration procedure was completed. That 5-year clock starts ticking once registration is final, as confirmed in the Bonn-Madden trademark case. 2. Section 46, 1B. At any time after registration, there has been a continuous 5-year period where the mark wasn't genuinely used. So if you register a mark, use it for a bit, then stop using it for 5 years straight, it becomes vulnerable under this ground.
What's the policy idea behind this use it or lose it rule?
It's about keeping the trademarks register clear and reflective of marks actually being used in commerce. It prevents people from squatting on marks indefinitely without using them, or registering marks defensively just to block competitors, Imperial Group v. Philip Morris. It ensures the register is a useful tool, not cluttered with deadwood.
Okay, but what counts as genuine use? It can't just be token use, right?
Exactly. This is a really key concept, defined by the CJEU in C4001 Ansel BVV Ajax brand Beveliging BV. Genuine use means the mark is used in accordance with its essential function guaranteeing origin, and the use is aimed at creating or preserving an actual market outlet for the goods or services protected by the mark. It has to be real commercial exploitation, justified in the context of the relevant business sector.
So not just printing a few labels to keep the registration alive.
No, token use solely designed to maintain the rights is explicitly not enough. The court looks at all the facts, the nature of the goods services, the market characteristics, the scale and frequency of use. Is the use commercially realistic? Is it enough to be seen as genuinely trying to gain or maintain market share?
Can you give some examples?
Sure. In Ansel itself, using the mark on spare parts and servicing for older equipment previously sold under the mark was considered genuine use for those parts services. Police trademark showed that the scale of use must be assessed relative to the size and nature of the business. Small use by a small business might be genuine. Varan Radetzky Orden suggested even non-commercial use by a nonprofit, like on headed paper, could potentially be genuine if it serves the mark's function for them. Laboratoires Goemar v. Lemaire technology highlighted that the quality and purpose of use can matter more than quantity. Very small sales aimed at genuinely establishing a retail presence were sufficient. And C7218 Ferrari SPA VDU recently confirmed that while simply reselling used Ferrari cars might not be used by Ferrari, using the mark in connection with providing services related to the resale of used vehicles, like authentication or specialized servicing, could constitute genuine use by Ferrari if it helps maintain an outlet for those services.
What if the owner simply couldn't use the mark? Are there excuses?
Yes, the owner can defeat a non-use revocation claim if they can show there were proper reasons for the non-use, under the opening words of Section 46.1. These reasons must be obstacles that are independent of the proprietor's will and have a direct relationship with the mark, making use impossible or commercially unreasonable. Think war, import restrictions, regulatory hurdles directly affecting the product. Cases like Magic Ball Trademark and C24605, Armin Hopley v. Little explore this. It's quite a high threshold.
What if the owner used the mark but in a slightly different form from how it was registered.
Section 46.2 addresses this. The owner can rely on use of the mark in a form that differs from the registration, but only if the differences are in elements that do not alter the distinctive character of the mark as registered. This is interpreted very narrowly.
So minor stylistic tweaks might be okay, but significant changes aren't.
Exactly. Remember Neutrogena. Using Neutralia was held to alter the distinctive character of the registered Neutralia. Similarly, United Biscuits couldn't rely on use of different penguin drawings for their registered penguin mark, and using Venice Simplon Orient Express was too different from the registered Orient Express mark in the Orient Express trademark case. It has to be essentially the same mark from the consumer's perspective.
Okay, so non-use is the big ground for revocation. What are the other two in Section 46?
Or the third ground, Section 46(1)(c), is if the mark has, as a consequence of the owner's actions or inactivity, become the common name in the trade for a product or service it's registered for. This is often called genericide.
Like Hoover for vacuum cleaners or aspirin for...
Exactly. If the mark loses its distinctiveness and just becomes the generic term for the product type itself, partly due to the owner not policing its use properly, it can be revoked. This is assessed from the perspective of the average consumer of those goods or services, Virnicula, Fructindustrier v. Procordia Food.
And the fourth ground, Section 46(1)(d).
This is if the mark has become liable to mislead the public, particularly as to the nature, quality, or geographical origin of goods services, as a consequence of the use made of it by the proprietor or with their consent. This mirrors the absolute ground for refusal in Section 3B, but here it's about misleading use after registration.
So the way the owner is using the mark makes it deceptive.
Yes. It usually requires the use itself to be inherently deceptive. In Elizabeth Emanuel v. Continental Shelf, the court found that using the designer's name wasn't inherently misleading even after she left the company, as the company itself was seen as guaranteeing the quality associated with the name.
Can revocation just apply to some of the goods or services listed in the registration?
Yes, absolutely. Revocation can be total, the whole registration goes, or partial. It's revoked only for specific goods or services. A common scenario is where a mark is registered broadly, say for clothing, but has only ever been genuinely used for T-shirts. It might be revoked for all other types of clothing due to non-use. David West v. Fuller Smith & Turner is an example where beers was too broad when use was only proven for bitter. Consumer perception of the scope of use can also be relevant here. Thomson Holidays v. Norwegian Cruise Lines.
Okay, that's revocation. Post-registration problems, generally future effect, doesn't wipe the slate clean for past infringement. Now, let's contrast that sharply with invalidity under Section 47. How is this fundamentally different?
Invalidity is a completely different beast and often much more potent for a defendant. The core argument in an invalidity action is that the trademark should never have been registered in the first place. It claims there was a flaw in the registration at the time it was granted.
So it's about a problem that existed right from the start.
Exactly. It challenges the validity of the registration based on the conditions that applied at the date of application or registration.
And the effect, if a mark is declared invalid. This is the crucial bit, right?
Absolutely crucial. A declaration of invalidity means the trademark registration is deemed void ab initio void from the very beginning. It's treated, legally, as if it never existed on the register.
Wow. So what does that mean for infringement?
It means the declaration of invalidity operates retrospectively. And because the mark is treated as having never been validly registered, it completely exonerates the defendant from liability for any past acts that would have constituted infringement of that mark. The basis for the infringement claim simply vanishes. Like revocation, invalidity can be total or partial.
That makes invalidity a much stronger defense tactic if the grounds exist.
Absolutely. Succeeding with an invalidity counterclaim kills the infringement claim stone dead, past and present.
So what are the grounds for declaring a mark invalid under Section 47(1)?
The grounds essentially mirror the reasons why registration should have been refused in the first place. There are two main categories. 1, the mark was registered in breach of Section 3, absolute grounds for refusal. This means the mark offended one of the absolute grounds, like being non-distinctive, purely descriptive, generic, contrary to public policy, deceptive, etc., at the time it was registered.
But isn't there a way to save a mark that was maybe descriptive at registration?
Yes, there's a very important proviso here, specifically for invalidity claims based on Section 3(1)(b), (c), or (d), lack of distinctiveness, descriptiveness, or being a customary sign. Even if the mark was technically invalid on one of these grounds when registered, the invalidity claim can be defeated if the proprietor can prove the mark has subsequently acquired factual distinctiveness through use after registration, but before the date the invalidity application was filed.
So use after registration can cure the initial defect.
For these specific grounds, yes. This is different from the proviso in Section 3.1 itself, which requires acquired distinctiveness before application for registration. Proving this post-registration acquired distinctiveness would likely require strong evidence, probably meeting the windsurfing Gene Z criteria.
Okay, that's invalidity based on absolute grounds. Section 3. What's the second category?
The second ground is that the mark was registered in breach of Section 5, relative grounds for refusal. This means the mark conflicted with an earlier trademark or earlier right, like passing off rights, at the time it was registered. The only exception is if the owner of that earlier right consented to the later registration.
So if my mark was confusingly similar to your earlier registration when I applied, you could seek to invalidate mine based on your Section 5 rights.
Yes, I could. However, this ground for invalidity comes with very significant limitations on standing and time. Firstly, under the trademarks, relative grounds, Order 2007, an invalidity action based on a conflict with an earlier right under Section 5 can only be brought by the owner of that earlier right. No one else can raise it.
So a random competitor can't try to invalidate my mark based on someone else's earlier right.
Correct. Standing is restricted to the owner of the allegedly infringed earlier right. Secondly, and crucially, the trademarks, Proof of Use Regulations 2004, introduced a time limit. The owner of the earlier right must bring their Section 5 invalidity action within 5 years of the date of registration of the junior mark, assuming they were aware of it, linking back to acquiescence under S.48.
So if you own an earlier mark and you see my similar mark get registered, you basically have 5 years to challenge its validity based on your earlier right. After that, it's too late.
That's the general rule. Even if you didn't oppose it initially, or if your opposition failed, you can still try invalidity, but only you can do it, and only within that 5-year window from the date my mark was registered. After 5 years of registration and awareness, the registration becomes largely immune from attack based on earlier relative rights. It's a rule designed to bring legal certainty after a reasonable period.
Right. That distinction between revocation, post-registration, future effect, no wipeout of past acts, and invalidity, pre-registration defect, retrospective effect does wipe out past acts, is just fundamentally important for anyone involved in these disputes, especially defendants.
Absolutely fundamental. Understanding which one applies, the grounds, and the consequences is key to strategy.
Okay, we have covered a massive amount today. We've walked through how a claimant proves infringement, actus reus, scope of protection, the crucial role of trademark use.
The Celine criteria, AdWords context.
Now we looked at the whole defensive playbook. Arguing the elements aren't met, consent, non-trademark use, the Section 11 defenses with that vital honest practices check, exhaustion of rights for imports, acquiescence.
Repackaging rules, consent, Davidoff, Bowringer.
Yeah.
And finally, the counterattacks of revocation and invalidity, highlighting that critical difference in their effect. Let's try and wrap this up by focusing on how listeners, especially students, can apply all this knowledge. How should they approach an infringement problem?
Okay, yes. If you're faced with a scenario, maybe an exam question, involving potential trademark infringement, definitely use that structured approach we mapped out earlier. It's your best guide.
So step 1, check the basics. Is there actually a registered trademark involved?
Foundational. Got to have that registration for statutory infringement claim.
Step 2, identify the defendant's action. Is it an act of infringement? Yeah, look at what the defendant did. Does it fall into one of the categories in Section 10.4, like affixing, offering, importing, using, and advertising? Or Section 103.2 for oral use? Could it be contributory infringement under Section 10.5, remembering the knowledge requirement there? And importantly, did the conduct happen within the UK, considering those online targeting rules?
Step 3. If there's an act, does it fall within the scope of the mark's protection?
This is the core analysis. Apply the Section 10 triad systematically. Is it double identity under 10.1? If not, is there similarity of marks goods and a likelihood of confusion under 10.2? Remember the global appreciation, interdependence, strength of the mark? If not, or in addition, does the claimant's mark have a reputation? And is the defendant's use, even on dissimilar goods, taking unfair advantage or causing detriment, blurring tarnishment under 10.3? And overarching all of this, is it trademark use that actually affects or is liable to affect the mark's functions, applying Arsenal and Celine? Don't forget context AdWords, Google France, Interflora, online marketplaces, iconics.
Right. Step 4. Assuming prima facie infringement, what defenses could apply?
Now you switch hats. Think defendant. Are the inherent defenses relevant consent or arguing it wasn't trademark use affecting functions? Then the statutory defenses. Section 11, own registered mark, use as registered. Section 11.2, own name, remember only individuals now. Descriptive use or intended purpose. And for all Section 11.2 defenses, rigorously apply the honest practices proviso using the Gillette factors. If imported goods are involved, deep dive into exhaustion, Section 12, Article 7, EEA first sale, consent, Davidoff, repackaging, Boermer rules. Is there a prior local right, Section 11.3, or statutory acquiescence, Section 48, registered versus registered, 5 years? Could honest concurrent use principles apply? Is it comparative advertising, Section 10.4, and CAD rules?
Okay. And finally, step 5. Could the vendor challenge the registration itself?
The counterattack. Are there grounds for revocation under Section 46? Think non-use, 5 years, genuine use standard from Ansel, proper reasons, genericide, common name, or misleading use. Remember, revocation's effect is generally future only, or more powerfully, are there ground for invalidity under Section 47? Was there a breach of absolute grounds, Section 3, at registration? Can the owner save it with post-registration acquired distinctiveness? Or was there a breach of relative grounds, Section 5? But remember the tight-standing owner only, and time limits, 5 years for Section 5 invalidity, and crucially, invalidity is retrospective, wiping out past liability.
That step-by-step framework acts, scope, defense, challenge really does cover all the bases, doesn't it?
It provides a comprehensive structure. By working through each stage, you ensure you hit the key legal points and demonstrate you understand how these different parts of the law fit together. And honestly, repetition is key here. Go back over those core sections 10, 11, 46, 47, and the landmark cases, Arsenal, Celine, Boehringer, Davidoff, Ansel, Gillette, Silhouette, again and again. That's what makes the difference for understanding and recall, especially under exam pressure.
Fantastic advice. That really helps pull it all together. Well, we have certainly gone deep today. We've journeyed through the rights of trademark owners, the different ways infringement can happen, and those really detailed rules about the scope of protection, like the whole evolution of trademark use, especially online.
And we spent a good chunk of time unpacking the defendant side, too, how they can argue the claimant has another case, or rely on those specific defenses. Own name, descriptive use, intended purpose. Always subject to that honest practices check.
We also untangled the complexities of exhaustion of rights, that crucial difference between parallel imports and infringing goods, the incredibly strict rules for repackaging, and the absolute centrality of consent, especially for goods from outside the EEA.
And finally, we looked at the ultimate weapons in the defendant's arsenal, challenging the mark itself through revocation or invalidity, really drilling down into the different grounds and, most importantly, the starkly different consequences each has for past infringement.
Yeah, it's so clear listening back that trademark law is this constant balancing act, isn't it? Weighing the owner's exclusive rights against fair competition, free movement of goods, allowing others to describe things accurately. That tension seems to run through almost every defense and exception.
It really does, and it's why it's such a dynamic area, with courts continually applying these established principles to completely new situations, new technologies, new business models.
Which definitely leaves us with a thought to chew on. As we see more AI-generated content, more commerce happening in virtual worlds, maybe shifts in global trade patterns, how are core concepts like use in the course of trade or targeting online activity or even the practicalities of exhaustion going to be interpreted and reshaped by the legal challenges just around the corner? And how might the UK decide to carve its own path on issues like international exhaustion now it has the flexibility?
It's a fascinating space to watch, that's for sure. It will keep evolving.
Well, we really hope this deep dive into trademark infringement and defenses has been useful, maybe clarified some things, and helped you on your learning journey.
And let us say thank you again to the University of London for making these valuable educational materials available. And also, thank you to Sinorbit Academy Sri Lanka for bringing you this deep dive today.
Absolutely. Wishing you all the very best of luck with your exams, your studies, and your continued learning in this fascinating field.